reference to Ms. Edmonds and the issue of her employment. You were of the belief that she is involved with blatant payroll fraud, is that correct?
Those were not my words.
But you continue to post items on your website.
Ms. Bankston, I think it's about the 5th time you've referenced my website. Can you produce a single hard copy printed out page from my website where I reference blatant payroll fraud?
Well,
The answer's no.
so you don't ever put it on your website.
I have not put blatant payroll fraud on my website.
Now, you actually sued Ms. Edmonds, correct?
That is correct.
Let me show you a memorandum that was filed in reference to the lawsuit in which, that lawsuit's been dismissed, correct?
That lawsuit has been dismissed. It was,
Go ahead.
the lawsuit certainly didn't entail payroll fraud.
Well, that's the interesting thing about it, Mr. Burns. This is I want to say, 51-page memorandum
Yes, sir.
in which it was involving the issue of an exception of no right of action and a special motion to strike. He made a number of allegations of Ms. Edmonds on an issue involving, as I recall, malicious prosecution. Was that it?
That was the initial, yes.
Okay. Let me ask you, Mr. Burns, to turn to
I don't have it.
page 7 of this document. Now, you say that you don't ever say this, blatant payroll fraud. All you're saying is you're repeating from somebody else?
That's exactly what I said.
Okay. So these references, for example, in exhibit number 8, the reference to, one second here. This exhibit number 8, in which you sent on July 12, 2012, to 3 of the board members, in which you said that your group, LAPA, has advised each of you in emails soon after 5/21/12 that the Chief of Civil Service Accountability, Patrick Lowery, has indicated that the Louisiana Auctioneer Licensing Board work arrangement constitutes blatant payroll fraud.
That's exactly what I said.
And in this,
And I'll point out, as you said, that was an email correspondence with 3 board members. You use the word internet website. Yes, that is an email I sent out, absolutely.
and then in this memorandum that
Okay, I want to object to this memorandum.
Okay.
You know, there's a limited privilege that extends to things that are filed in pleadings when you're making good faith arguments. And that pertains to this memorandum, although it was improper person. And I would like to know, and I think this board ought to, you need to make a ruling on what provision of the statute the allegations and questions that council is going into have to do with anything that's before this board.
Let's back up, exhibit 8.
Your Honor, may I say something? Anything?
Not at this point.
Okay, well,
I'll let you talk.
on a point of order though, anything you say in pleadings, as you know, you have immunity for. You have immunity, anytime somebody files a pleading, they have immunity under the case of Levy versus O'Bannon, which is my case, United States Supreme Court case that went up to the United States Supreme Court. And I'll give you the details if you want. I don't see how you can hold anybody responsible on anything they put in pleadings. So look at the case. Go pull it. The leading case in
I
Louisiana.
have absolutely no knowledge of that. President.
Well, it's involving me personally and a lady named Sula O'Bannon from Baton Rouge. We made the law in 1983 and it's still the law now. It's not been changed. I think it's bad law, but it is the law.
Let's back up. Exhibit 8, which is the email. Are you going to
offer to introduce.
Okay. Any objections to exhibit 8? I don't think
The
we have.
email?
Yeah.
No.
Okay. Going to be exhibit 8. Exhibit 9, which is the memorandum that was filed here in the 19th JDC. You've asked Mr. Burns a couple of questions about this. Are you going to I don't think it's been offered yet. Are you objecting to the questions? Are you objecting to the admission of evidence?
Both.
Under what grounds are you objecting?
Well, I'm objecting to having any relevance or materiality to anything before this board, because there are 12 grounds under 37, 31, 21A that this board may consider here today. And I don't know of a single one that any of this issue dealing with, and I forgot her name, what's her name? Ms. Edmonds, deals with, because number one is a conviction of a felony. That doesn't apply. Number two is deceit or perjury in obtaining any certificate or license issued as chapter. That doesn't apply. Number three, providing.
What are you running down?
I'm running down the specific
Okay.
statutory points that this board can consider, and this doesn't deal. Number three is providing false testimony before the board. I don't think it's going to be or has been established that this gentleman has given any testimony before the board, but at the worst case, there's been nothing presented, and I don't think there will be anything presented about statements about Ms. Edmonds before the board, and this lawsuit, notwithstanding, has nothing to do with anything before the board. Number four, efforts to deceive or defraud the public. I don't see how anything, statements that this man made, whether it's actionable by Ms. Edmonds or not, begs the issue that defrauds the public. Incompetency or gross negligence. I don't even have to talk about that one. Rendering, submitting, subscribing, or verifying false, deceptive, misleading, or unfounded opinions or reports. That would pertain to opinions or reports pertaining to the auction business. Statements about Ms. Edmonds have nothing to do with that. 7 is refusal of another state to issue or renew a permit or a license. That has nothing to do with it. 8 is aiding or abetting somebody to, so you got to go back to the first 9. 9 would be violation of rules or regulation or rules of conduct promulgated by the board. None of those have been identified in filings in this matter, so I assume that there's no offering on behalf of the board that pertains. 10 has to do with indebtedness to a state or municipal corporation for any tax as an auctioneer. That would have nothing to do with Ms. Edmonds or statements there too. Selling good at an auction, number 11, without having first entering to a written contract, have nothing to do with any statements pertaining to Ms. Edmonds. And then number 12, failing for a period of 7 calendar days after notice is given to make good on the check, which is to return an SF. That would have nothing to do with any statements regarding Ms. Edmonds. So this entire litany of questions and issue about Ms. Edmonds, whether it was or wasn't done, has nothing to do with anything that's material before this board today.
And I think we ought to move for a directed verdict. I agree with you.
So moved.
You can explain what that is. I'd be happy to explain it.
It's not the appropriate time for that. And I don't believe that's available yet.
Well, I think it is, even at such a hearing.
I think we can limit what we're going into, Your Honor. We'll be here for hours because it has nothing to do with what's before this board.
You've made your relevancy argument. If Mr. Bankston has an opportunity to respond, if you like, feel this topic.
Rendering, submitting, subscribing, or verifying false, deceptive, or misleading or unfounded opinions or reports. It's not restricted just to, there is no case that says it's restricted to just what a person does as it relates to his official duties, but providing false and misleading information with the intent to try to create the impression that the executive director of this association has been involved with blatant payroll fraud. There's no question that that's false and misleading, with the continued attempt to provide that information, not only to by email, but also by filing an extensive document in which it's replete with language about this.
Okay. With respect to the document, I'm going to allow this as a pleading in a district court. The document is going to come in. With respect to the questions, we're going to go question by question. You can make your objections as with respect to relevancy. But the document's going to come in.
Mr. Burns, do you believe that Ms. Edmonds is involved in blatant payroll fraud?
Now, what's the relevancy of that, his beliefs and his opinions?
I think it's relevant. Why do you think it's not?
Because it does not pertain to any issue that this board can sanction him for, whether he believes it or not, whether he's incorrect or not. It might give rise to Ms. Edmonds having her own grounds for filing a suit for defamation, but it has nothing to do with what's before this board.
I think it's relevant. You can answer the question if you can.
Based on what I was told by Mr. Patrick Lowery, and based on what I was told later that same day by Mr. Calvin Moore, which Mr. Lowery recommended we go to at the Legislative Auditor's Office. In fact, he sent me a letter dated April 1st, 2011, expressing pleasure with the fact that I had gone on to the Legislative Auditor's Office with that. Mr. Lowery also suggested I contact Channel 9. I did so. Paul Gates won't remember it now, but unfortunately, because of his diagnosis, I did so. Mr. Lowery also suggested in this three-way phone call that I have documented here on November the 8th, 2011, that I contact you on your side. It's amazing that apparently I guess he would now see no problem with all these because he did nothing, but we can also have the sworn affidavit of Ms. Sherry Wilks that he most certainly said it was payroll fraud. I'm not qualified to make the judgment of whether or not this was payroll fraud. The entirety of the video of January 10, 2011, wherein this board approved that employment agreement, which is right here, was seen by all of these parties. And, let me strike, let me not strike it, let me correct that. Do not know for a fact that Mr. Lowery watched that video. Mr. Moore certainly had, and he said that having a cell phone in your person and being on call for a job does not constitute being on the clock. Furthermore, Mr. Moore was shown.
I like to object. It's just non-responsive to.
You asked me, and I'm sorry, you're in charge, I'm sorry.
You can finish. You can finish.
Yeah, you're the judge.
No, he said you
I'm
can finish.
allowing you to finish your answer.
Okay, you asked me what I believe. I am laying the foundation for what I suspect. I never said this is blatant payroll fraud. I'm not qualified to make that determination. I have quoted a number of people who are, in my opinion, and I rely upon them. If they gave me bad information, and as I said, Ms. Edmonds sent me an email dated, I think it was, I'll have to pull the folder, which she said I can't do, June 6, 2010, indicating that she was not going to be available the entire next week. None of it. All right? And she says, Ken is aware I'll be out. Yet on her payroll records, she shows that she was on the job not only for this board, but for the other board during a week-long vacation. That's what Mr. Moore said is a serious problem, Mr. Bankston. And I have those emails, I have the timesheets. So, I have some grave concerns, especially considering it's my money that is, it's the other licensees too. But my concern is with the board permitting this. And I might add, Mr. Lowery said, and I'm going to quote him, how could any board be so stupid as to have approved something like this? End quote.
Finished?
Yes.
Okay. Now, in reference to your comment, were you not told by Mr. Lowery that Ms. Edmonds is not a civil service employee?
And I have repeatedly said that, and that's why he referred us on to the Legislative Auditor's Office. He also said if he had the authority, he would start immediate proceedings for payroll fraud. I said I don't know how far you're going to get to Ms. Edmonds on payroll fraud, given that she has the blessing of the entire board.
So you think it's payroll fraud?
Mr. Bankston,
You think it's
Mr. Bankston, you have asked that question, and I have answered it. My belief is based on experts, or so-called experts, to which I've been guided to. We didn't go in there and say, is this payroll fraud? Because, and I say we, it was me, myself, and Sherry Wilks. Fred Phillips is not here now. He was involved in these meetings, okay? We were never at any time told not to continue collecting payroll records. We were encouraged by Mr. Moore to continue collecting payroll records. I submitted Freedom of Information Act requests, and then we gathered the payroll records. The Legislative Auditor's Office came in. I don't know whether they wanted to skirt the issue by saying she's not even entitled to accrue leave, period. That's what they did. I recognize the governor's office said, well, we're making an exemption, but we're cutting out these like employees. But all I can tell you is, from Mr. Patrick Lowery's office to everyone that I spoke with at the Legislative Auditor's Office, they never once said, we don't believe there's problems here, not one time.
has anybody told you that there's payroll fraud in reference to the classification of a non-classified employee? Has anybody told you that?
Mr. Patrick Lowery did. But he said he had no authority to pursue the matter.
For a non-classified employee?
Yeah, he said if she was classified, he would commence immediately.
And if she was unclassified, he had no authority, and they don't.
I have never denied that. That's why he sent us on to the legislative. He also said you could go to the Inspector General's office with this, but we opted to go to the legislative auditor's office.
And did they do anything?
Did the legislative auditor's office do it? Yes, they came in here and conducted, and they said, that, like I said, I'm sure you've seen that report. It clearly says she should have been accruing leave. So I don't know where, they sent me a subsequent follow-up. I do not have that email here with me, but they said we do not consider this issue dead, so that we're not going to be at liberty to divulge to you what we're going to do from here.
But you continue to refer to it in pleadings and opportunities to discuss it, continuing not to describe that Ms. Edmonds is a non-classified employee, but continuing to refer to Mr. Lowery as the person contributing this issue of blatant payroll fraud.
Mr. Bankston, the email as well as the video, and I have the video to play it back for you, said I would strongly encourage this board to modify its existing employment agreement. I have a copy of that employment agreement. If you read section D, it clearly allows her, she has every right to do it now because the board's given her permission. She has every right to go out and lay on the beach and claim she's on the clock. And so I have said, given the statements that have been made by government officials, I think it would behoove the board to modify the employment agreement. Every time I've made that suggestion, it's just fallen into, a deep well. So if the board wants to continue with that written policy, and when they face the next audit, say, where's her employment agreement? And it still says the same thing it said when James Comer signed it on January 10, 2011, and Greg Bordelon served as one of the witnesses, that's fine. They can do that. I'm just saying, I don't think it's advisable.
No, you're more than saying it's not advisable. You're saying in pleadings that Ms. Edmonds deems committing blatant payroll fraud by Louisiana Civil Service Chief of Accountability, Patrick Lowery, even though you know for a fact that Mr. Lowery will tell you that they have no jurisdiction whatsoever over unclassified employees.
That's just an argument, Your Honor, that can be addressed by Mr. Bankston in his closing statements. That's not a...
You want to say?
What's the question again, Mr. Bankston?
You continue to put in pleadings and on your website or on emails in which you continue to refer to Ms. Edmonds' activities as blatant payroll fraud.
That's an interact, I'm sorry.
I'm going to agree with you and sustain that objection.
He said that he had covered.
Meeting is now back on the record.
Okay, back on the record, Mr. Bankston, your next witness?
Patrick Lowery.
Okay, Mr. Lowery, can you please swear Mr. Lowery?
Please raise your right hand. Do you solemnly swear the testimony about to give in this matter will be the truth and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Lowery, I understand that you have a loss of hearing in one ear. Okay. Please let me or the board know if there's any difficulty.
All right.
Could you give us your name and address?
Patrick Lowery, 1759 Stafford Drive, Baton Rouge, Louisiana, 70810.
And what is your position?
I am the Division Administrator in the Department of State Civil Service Program Accountability Division.
What does that mean, accountability division?
I head the division that is in charge of investigations and audits.
Do you recall there being occasion sometime back in November of 2010 in which Mr. Burns, Robert Burns, came to see you? Do you recall that?
Yes, sir.
Do you recognize Mr. Burns?
Yes, I do.
At that meeting, did you indicate to Mr. Burns that you were of the opinion that Ms. Edmonds had committed blatant payroll fraud as a result of the activities?
That is not a correct assessment of what was discussed in that meeting. Mr. Burns came to me. He was accompanied by a lady, I cannot remember her name. We had discussion about some concerns he had about the operations of the office. and the hours that the executive director was keeping. We went back and forth with that for a short time. Mr. Burns was alleging that the conduct violated the leave rules in Chapter 11 of Civil Service rules. And we discussed it, and I pointed out to Mr. Burns that the person in question was not a classified state employee, and therefore was not under our rules. He countered at some point in time and insisted that she was still under our rules, and I said, what you're essentially alleging is payroll fraud that is not under the authority of civil service. You need to talk to the Inspector General or the legislative auditor. I cannot remember the exact word, but that was the gist of what I said.
So it would be a fair statement that a representation that you had indicated after hearing the information about the activity of Ms. Edmonds, that you did not indicate an affirmative decision on your part that she was involved with blatant payroll fraud.
I had conducted no independent investigation and had no facts other than what Mr. Burns relayed to me.
That's all the questions I have.
Mr. Lowery, the woman that came in with Mr. Burns, was it Sherry Wilks?
That sounds possible. I don't really recall.
And isn't it true in that meeting that you had with Mr. Burns, and I'll represent to you as Ms. Wilks, that she did the vast majority of the talking as far as providing you with information and asking questions?
That I cannot remember.
You in one of your answers, you said that you told them what they were alleging is payroll fraud. I'm quoting. Is that what you told them?
Well, I told him his allegations were, if you have an employee that is being paid for hours they did not work, then that's payroll fraud. But I was not concluding anything. I was simply redirecting him to the agencies he should talk to.
And you recommended to Mr. Burns and the woman that they, one of the persons they might go see would be at the legislative auditor's office?
That's correct.
Did you specifically recommend that they see Mr. Moore, Calvin Moore, or just in general?
I don't know anymore.
Okay. And I understand your answer was that you didn't do any independent investigation, but am I correct in understanding what you told them was in response to the information that they were providing to you, unverified by you, that would constitute payroll fraud, but it wasn't a civil service employee, you had no jurisdiction? Is that a fair statement? That's all the question I have. Thank you.
No further questions.
Any questions from the board for Mr. Hall?
I have a question. Can you hear me, Mr. Lowe?
Yes.
Okay. When he came to you, he came to you not necessarily to tell you something, but to seek your opinion. Is that correct?
Mr. Burns was attempting to file a complaint with the Department of State Civil Service under Chapter 11 of the Civil Service Rules.
But he wanted to seek your opinion as to whether or not this was payroll fraud before filing a complaint. Is that correct?
I don't know. Well, he was attempting to file a complaint.
And you advised him that it wasn't covered under the Act. Is that right?
That's correct. He was an unclassified employee, and he is not covered by our rules.
So he was nothing more than an average citizen seeking to file a complaint or to seek your advice on whether or not he should. Is that right?
That is correct. I mean, he wasn't seeking my advice on whether he should. He was trying to file a complaint as any average citizen that I deal with on a day-to-day basis does. This was a very routine conversation for me.
And he didn't come to you as an auctioneer and said, I'm an auctioneer, and because it's an auctioneer, I want to file a complaint against another auctioneer.
I believe he did represent himself as an auctioneer, but I don't know, I really don't remember that.
Okay, if you don't remember it, I don't want you to guess, please, because you are under oath
Right.
in this forum. So, and you gave him your opinion, and as a result of that, he accepted that particular opinion as an average citizen would. Is that correct?
He took the information that I provided to him and left.
All right. Now, how often do average citizens come to you, or people come to you with allegations to file complaints? How often do you get that?
It is infrequent at times. I mean, I may get 3 or 4 in a week. I may go 3 weeks without getting one.
And when they come to file a complaint, you're going to give them your opinion as to whether or not they have a valid complaint.
Sometimes, if it is something that is clearly under my jurisdiction, I don't really give them a jurisdiction. I just accept their complaint, log it in, and conduct an investigation.
But any citizen in Louisiana, as an average citizen, has the right to file a complaint. Is that correct?
That is correct.
All right, thank you.
Any other questions from the board? Mr. Lowery, you're excused.
Thank you, Mr. Lowry,
Thank you,
appreciate
sir.
it.